Actually, the right time, though, huh?
I go back to
Probably pretty close.
Actually, my phone.
Welcome to the party.
We're gonna go undefeated at home there for a while.
this is the year. This is the year.
That the 20-game win streak actually went against the Celtics on that. Again, with the playing the Nuggets, that was easy. It's like they're not gonna. They don't need it. You know, the Nuggets want to win that game. We're gonna rest.
You ready?
Ready when you're ready.
It's done.
All right.
All right.
All right.
As soon as these TVs go live and everybody see what we're talking about. So we'll get a text. Well, while I have you guys all here, tomorrow at 10 a.m. we're all, if you have any questions or anything in advance, just shoot them to me. All right. Thanks, Wes. So, we're here on January 23rd for what I think is our sixth STR work session since November. This is our cover sheet, which has kind of been carried over to show the status of the discussions. I believe we're getting closer to some final language on some of these things. A reminder, we do need to have second reading of any ordinance changes done prior to March 1st. This was when business license renewals start. The green items there, which we'll go over later, I think we're close enough that I've got some actual final proposed language. The yellow/orange, those are ongoing. There is some draft proposed language to be further refined today, and then at another meeting or another meetings if necessary. The wait list procedure. I do want to just call attention to everyone at home and here in the audience. The ones with lines through them, those are the things that have been removed from consideration at this point. They've been presented a couple times throughout the process. We're going to proposing not to move forward with those. And then way down at the bottom, the remaining additional study areas, which are going to be separate from this ordinance amendment. Close is good. It's going to be separate from this ordinance amendment process. We'll do a session on enforcement, and if we need to look at the septic pump out requirements, we can do that. A note about the septic pump out requirements. Rental properties are required to pump their septics once a year. That is not a requirement to have an approved registration. So we can move forward with the registrations. Well, we don't deny registrations if you haven't pumped out your septic tank. What we do is we flag you for non-compliance with the related ordinance, and you can be issued a citation for it. So it doesn't actually stop you from getting your license. So it's not urgent. We need to do it before March 1st. So that's our top sheet. And we will just kind of jump right into it. We're going to start with the orange/yellows and then move through the greens. Last week, or at the last meeting, we talked about inactivity. We asked for some more time to get some number of nights, a proposal for number of nights. Still got 2 weeks down there as a starting point for discussion. But what we were able to do is get into our new software and by hand tally up all the nights rented showing for 926 of our ISTR licenses to kind of give us an idea of how much properties are being rented out here. Separately from that, we've been working with some owners to kind of truth check the software. It is not 100% accurate, but it is reasonably accurate. We've got a very small sample size. As that sample size grows, I'll be able to give you better information about how accurate it is, but we have truth tested it against a couple of properties. Number one issue is that for short owner bookings, it seems to catch those as nights rented. Longer owner bookings seem to be fairly consistently ignored. But there hasn't been a case in the very limited, less than 10 at this point, sample where the software has been off more than 10-15%. So it's close. It's not perfect, but I think it's close enough that we can use these numbers as an estimate. But I do have that asterisk there. This is all software provided data, and the software is not perfect. But of the 926 licenses we reviewed, those licenses were issued for a total of 122,000 rental nights, 122,142. The average nights was 129, and the median night was 149. So those are pretty high rates. Below it, we've got a breakdown of 4 weeks or fewer. We didn't go any further than that, but I personally was surprised at the high night average, and that's 129 nights. That's a pretty high average for us. So I think the number of nights rented, at least for me, came back higher than I expected. And then we just looked at no rentals through 4 weeks of rentals, and these numbers are cumulative. So there are 219 properties that show 0 nights rented. There's 224 that show 7 or fewer nights. That 224 includes the 219 below it. So you go to 219 properties with 0 nights, and the only difference between the properties reporting 0 nights and the properties reporting up to 4 weeks is 232, which is 13 properties. So there's a really narrow range of folks who are renting up to four weeks. And as you go over 4 weeks, the spread starts to grow a little bit. We do have all the way up to 10 properties that report more than 300 nights rented. We have not been able to perfectly truth check those against owner records yet, but our goal is to get a couple of those really high ones too, and make sure the software is not doing anything funky. I was surprised to see 10 properties with more than 300 nights rented. It's an ambitious turnover.
And this breakdown is all ISTR, not
Right.
okay.
Right, yes, sir.
Perfect.
So since we're only considering ISTRs, an owner can get a license at any time, so they don't need a minimum amount of activity. So that's the breakdown. 232 properties, less than 28 nights. 219 of those are 0 nights. And we've got that 14 night out there as a starting point. That would basically be 2 rental periods if we go by our traditional weekly rentals, or up to 7 rentals if we go by our minimum 2-night rental.
Was that the rationale for 14 days?
Yeah, just
You just picked a number.
It's a round number that fits with either a weekly rental or minimum night rental activity.
What's a number that we don't think will be easy for people to fudge? Because I think that's where we were getting, our discussion kind of went to, and feedback we got from other people were saying, hey, you can still, fudge numbers or amounts and all that. So that was the biggest concern I think we all had when we left last time, was how do we find an adequate number that is just hard for people to just rent to their brother-in-law.
Well, plus, when you go from 0 to 232, that's a minimum number of places, but when you look at, it just worked out that 14 nights happened to be the median for those numbers.
Yeah.
So it worked out.
But there's really no difference in 14, or if we do 30 nights, there's not much of a difference, but is it harder to fudge 30 numbers than 14? I mean, that's what we're looking to find, I think, is a way for people to be honest about their rentals.
I would like to see that number higher, is mine.
That's what I'm going with.
Yeah.
I think it definitely needs to be higher. I see where you got 14 from, but I just want to know how we're gonna monitor that. I mean, that seemed to be everybody's biggest concern was, well, they can still do that. So we don't want somebody to beat the system and then nobody else is,
Yeah, I think folks are always going to beat, the determined person is going to beat the system no matter what you do. But in terms of monitoring it, at the end of the year, we'll run the same report and we'll flag all the ones with less than the number of nights we set at a minimum, and we'll ask them to produce their records from their minimum manager.
Gotcha.
And show us. So the more nights, the more contracts that would have to be faked,
Right.
the more effort it would take.
I would say, 28 or 30, whatever you consider a month.
I think going to DJ's point, we don't impact that many more families or properties if we go to 4 weeks as opposed to 2 weeks.
Works for me.
I agree.
Yeah, perfect.
So we'll switch out for 28 nights. And what we can do is, as we continue to refine our sample size for direct comparison, we'll pull the next handful of properties from around that 28 night range and test the software against folks' real records and see how it comes back. I'm really interested, honestly, in the 0 night properties, just to make sure, because I was surprised at how high it is. But we found a couple that were 0 and reported 0, so it worked.
I mean, if you just look at the numbers, at 14 days, if those are really less, it's 227 off the 926, it puts us 101 below the cap.
But we've done that for a while. It's just, everybody else is getting to see it now.
And a good point about that is, correct me if I'm wrong, but I've understood this to take effect next year. So they have this year to meet the minimum requirements rather than make it in effect for this current renewal, because there was no minimum requirement
Right.
this year.
That's fair.
Yeah.
Yeah,
I agree.
the 24-25 year. It's in effect.
So that was inactivity. I kind of combined partially rated properties and heirs properties here with the LSTR. Again, looking at LSTR as kind of a multifunctional thing to wrap up a few of these things at once. All the under constructions, commercial, multifamily, all those are dropped. The only things that are remaining is a direct one-for-one replacement for an OSTR, so no change there. But it would add 72-day rentals for the legal heirs of any property and these partially rated structures where you've got a legal residence that's got a 4% rate, but part of it is taxed at 6%. We do have at least 3 properties that we know of now that have this special blended tax rate within the same dwelling unit. And this would be a change for them going forward to limit them to 72 night rentals. So the county has said from a property tax standpoint, that owner could do unlimited rentals. But we believe it'd be easier to manage to give them the same 72 days, because it is a legal residence, to give them the same 72 days. So for partially rated properties, this would mean if you have a 4% home or one room 6% because it's a rental, you could get a license to rent that room 72 nights going forward for new licenses under that category. Then there's the direct one-for-one replacement for OSTR, and then the proposal for inheritors of properties. And the exact language will certainly need careful review by Joe to make sure it does what we want it to do. But this would basically say that anyone who owned property out here on the day the referendum passed, 4%, 6%, any property owner, if you passed away, your beneficiary, son, daughter, cousin, uncle, uncle from Nigeria, anyone, could come in and show that they had inherited that property and get a 72-day license. I wrote this rough draft with the idea that the estate could apply within 90 days. We've gotten some preliminary feedback that that might not be long enough for an estate to apply. So this could be reworded to say the license could be obtained 90 days after the estate is settled and the property is transferred to the new person. But the idea is property owner dies, estate is worked out, new owner proves they inherited the property, they have 90 days to get a license after they officially receive that property.
I agree with everything you got, except I still say it should go to an ISTR.
That's
You inherited, it should go to an ISTR. We're talking about 1 or 2, probably not even 1 or 2 a year, but it's a very, very minimal number because you got to die to give it to them. So it's not going to be like there's 40 of them in a year that's going to show up. And I think that would answer most of the residents' questions about inheritance for their
If they already
beneficiary.
have an ISTR?
Huh?
If they already have an ISTR?
No,
No, just
they have
regardless.
90 days to apply for an ISTR.
I like that better for when it doesn't introduce the LSTR at all, and it doesn't contradict, 'cause my question was gonna be what you have on your summary contradicts with what you have here. You have allowing heirs to obtain ISTR licenses on your summary sheet, but then here it says LSTR.
Sorry, you'll see that. That was just a typo in my summary. It's got ISTR and LSTR.
No,
in it?
I think it's a type of beer.
I like the typo, but I'm just saying,
Alright.
I still think that an heir should be able to get an
All
ISTR.
right.
We spoke about it the other day, Tim and I, and you're gonna have one or two a year, and that is one of the biggest questions, biggest email concerns that we've had from residents is about the immediate heirs, not, your second cousin from your third wife, your immediate heirs, and that takes them off the books for one or two, especially with what we just saw with the minimum rental activity,
And we're gonna say one-time transfer on it.
Yes, just a
Yeah.
one shot, that's
Right.
it.
Yeah, and that's why we
To
threw it.
immediate family members, you mean?
Well,
Heirs that are immediate family members?
That's what we had
That's
discussed
what,
before.
that's
We'd have
what
to
we
spell it
discussed
out.
to start with, but that's,
as they said.
So that brings up a separate, we'll make sure we talk about that too. So first ISTR. Any other feedback on heirs, ISTRs?
Would that number go against the cap, or would it be exempted from the cap?
It would be allowed over the cap, but it
It
would
would
count
count.
towards.
Towards the cap,
yeah.
okay, okay.
Yeah, it would
That makes
still be
sense.
like anything else, but,
Okay, but it'd be an exception,
yeah.
okay.
And if we did that, then we would just take away LSTR and make A and C part of an OSTR. And then, okay,
Yeah, that's
so
fine.
I think general consensus on ISTR for heirs. And that's why we threw in the February 7th, 2023 owner of record. So that's just the folks who owned the property when the thing passed.
Yeah, prior to February the seventh.
Yeah, so if you sell your property to someone new, their heir doesn't get it. If your heir gets the property and they die 3 weeks later, their heir doesn't get it. So that's ISTR. And then there's the concept of who is an inheritor. We've got it written now that anyone who inherits the property, I'll just use myself as an example, I don't have children. My immediate family will not inherit my property. Someone else that I love and trust will.
I agree with you. It needs to be brought out for just children because, I'm in the same boat.
But the original immediate family we had was like
Yeah.
children, mother, father,
Yeah.
mother-in-law,
Whatever.
yeah.
Yeah, okay.
Family member,
So it wasn't just
as
kids.
opposed to your dog or.
Yeah, your dog's not getting the house with an ISTR.
Okay, so,
My dog gets the savings account.
Mr.
So Dr. Hudson?
okay, so I definitely admit I'm confused, because I thought we potentially were going to call it a beneficiary. Is that a different conversation, or am I?
That's conversation.
That's, okay, so I would advocate, because I don't want to make a decision who someone's beneficiary or who should receive it. What is immediate family?
Well, we're not saying who should receive it.
I'm just gonna continue just to finish that, and then, if I could. And so in light of that, if I am confused, then please explain to me. I thought that we were going to go with language such as beneficiary or inheritor.
No, that was your thought. That wasn't a consensus for everybody.
Okay, so.
And we're not saying who can inherit the property. We're just saying if you're not an immediate family, you're not gonna get an ISTR. You can inherit the property. You can go live there and you can get a 72-day license, but you're not gonna,
And we would probably, we define what we mean, family member. There'd be a list.
yeah,
Spouse, children, siblings, parents,
Yeah.
grandchildren.
So are we saying
What
then,
about nieces and nephews?
so are we saying nephew, just continue with just clarity. So nephews or a charity and things of those natures do not,
not necessarily if they're not on the list.
So we'll have to come up with the list.
You can
Is there-
always make an amendment to add somebody to the list.
Yeah.
I'm a fan of nieces and nephews because that's who everything of mine goes to is my nieces and nephews.
And that's fine, but I wouldn't be inclined to include charities.
No, yeah.
That's different.
They're not even
That
near a
becomes a
family member.
business.
I'm putting it out for subject of discussion, so we're still discussing?
Yeah.
We will work on a definition of family. We'll work on the family definition. So for this topic, LSTR will go away and we'll just stick with our OSTR, available for 4% folks and available for the 6% property tax rating. And then the heirs will be classified as an ISTR type, and we'll amend the definition of ISTR to allow that, and we'll come up with a definition of who can inherit for debate.
I like it.
Are you saying-
No, we're not debating who can inherit. We're debating
Sorry,
who we're
can
gonna
get a
give an
license.
exception
Yes,
to for a
yes,
license.
Yes, sir.
Okay, I just have a question about the 90 days. Are we going to change that
Yeah,
to?
yeah.
settling estates or,
Probably from the transfer of ownership.
okay, so that'll be
So
added?
the deed of distribution.
Is that what they, I was surprised you heard the 90 days wasn't enough. What are you thinking would be
Well, I
enough time?
think, and what I meant by that was, I wrote it, when I wrote it as a draft, my idea was the estate could apply within 90 days, and then they could have 3 years to work out the estate.
Right.
The state would carry the license. But instead of saying that, we just let the state carry the license by right, and then when the estate is settled, however that shakes out, that person has 90 days from the end of the estate, basically.
Gotcha.
Well, wait a minute, the state wouldn't have a license.
Well,
Yeah.
Not the way we're talking, the state
Yeah,
wouldn't have a
if they don't
license.
they don't currently have one, they wouldn't have one for the estate to
Well,
use.
right, that's why I included the estate, to allow the
So
estate to.
we're gonna allow you to let that percolate and come up with some better language for next time.
Yeah,
Well, I
that's,
mean, I wanna make sure.
I think we all know what you mean, and we're
I
all
wanna
on
make sure
board.
I understand what you guys mean. Are you guys meaning that person A has a license, he dies, his estate cannot get a license, but the person who gets it from the estate?
No, we're talking about if person A dies and doesn't have a license, nephew, son B, then the estate wouldn't have a license to carry over until it's figured out, even though we're saying that.
Who's gonna be
son B
inherited?
would be able to
All
get
right,
one.
okay, so that's for non-licensed properties. For licensed properties, do we want to let the state carry the license while it's worked out for the
If
person?
that's the easiest way for it to gotta go through their process and our process, then that's fine. To me, that's more of a technical thing of, I don't know which is easier for the state and for the city.
I wouldn't let the estate carry the license, just because in the end, you're gonna have to end one license and start another one, so it don't matter.
Yeah.
And, you know, it's like,
But how long does it take to settle an estate for something like that,
It can
to
take-
give them that?
it can take whatever.
Long time.
months,
As-
if not
Can I
years.
say something? As of now, we've had this happen before the referendum thing, and while it was going through probate, the license was kept in the owner's name, who passed away, renewed it, went through probate, went to the father, then the father, when it was time for renewal next year, the father received a new license in his name.
Okay, so my question is, if we allow the license to go on and we allow them to continue to rent, when we have a problem, who do we contact? The probate court?
No,
The
the person who is inheriting the home, which at
We
that
don't know
point
who
was
inherits the
father.
home until the probate
Well,
court
we did
does.
in that point, like, they had to tell us, and he came in, the person who was inheriting it, the father.
Okay, so what happens if the house, I'll just use myself as an example. When my parents' house went through probate court, it was gonna be 3 people inheriting it. So while it's in probate court, they don't know who's gonna inherit it. And in the end, it's like, I sign it over to you guys, and y'all go do whatever you want to with it. So it's 2 of them inherited it. So that's back to my original question. When we have a problem because it's being a bad rental, whoever they're renting it through, who do we contact as the owner? The probate court?
Administrator.
Yeah, so somebody.
So the administrator being,
Let me,
okay,
I mean, I haven't researched, but I'm really thinking it coincides with what Stacy said, that the state, they hold the deed in the name of the deceased person. And there is an administrator, and they're in charge of running things during that estate period. And then at the close of the estate, and that's why I actually suggested this change, because of the point you
Yeah.
made, you don't know who's gonna own that property until
Right.
it's deeded out of the estate. So that should be probably the trigger. And the administrator, I mean, they're supposed to be running things.
so the only reason I bring all that up to get to this point is, if we're gonna allow it to run in probate court in the estate, then we ought to say somewhere in there that the point of contact will be the estate administrator. Whoever that is, whatever lawyer, whatever person that is, would be responsible for that property.
I agree.
The administrator is usually the family member, right?
It could be, or you could
I
hire an
mean, some
attorney
people
to,
get-
there's plenty of attorneys out there that take your money to rent them.
So, for a property that does not have a license, person dies, no one gets the license till the estate's settled and the ultimate beneficiary comes forward. For a property that does have a license, the estate continues to pull the license until it's settled, and then the ultimate beneficiary comes in and applies for a new license. Is that
That's the way it has to go. Because it's gonna change, it's gonna transfer ownerships at that point in time.
All right. So, go ahead, Stacy.
Before you move on to 4%, 6%, so if this goes forward, those properties that are operating like that now will just go back to 72 days. Is that what we're saying?
Yeah.
Yeah.
Okay, so those owners would lose.
Say that again?
Yeah.
So we have 3 that we know of.
It has a room that rents in a 4%er.
So they're partial,
They're partially rated.
And they're partial.
And for tax purposes, the county says there's no limit on the number of nights they rent. It's a legal residence, but since they're partially rated at 6%, they can rent unlimited and not lose that overall 4%. We're saying in order to qualify for that license, you would have to rent 72 days or less. Like every other.
Like every other resident.
Like every other 4%.
But they're paying 6%
On one
on that
room.
one room. So we're talking about one room, or are we talking about multiple rooms?
So.
That goes back to the chicken and the egg, and we've had that discussion
Yeah,
before.
But we've got
it's
3
a portion of the
properties.
structure is taxed. No, it's not separate dwelling units, it's a portion within one
It's
dwelling.
Right, right.
unit.
Across the
understand
board,
that.
it's all 4% would be the
But
same.
you're looking at 3 properties, and how many bedrooms are we talking with those 3 properties?
I don't know, but, so the county very specifically clarified that like, the rental
They just got
is
that.
not limited to just using the room that has 6%.
Oh, they can use all of
Yeah,
them?
yes, sir.
But, yeah, I was
Okay,
gonna
right,
say,
well, okay.
I rent you the bedroom, but you got to run the whole house. I mean, there's, you know, we
And we have that-
don't allow you to make a duplex
Yeah,
by
we
building
have
a
that
separate
right
apartment in
from the
that
county.
residence.
It's in the residence.
And so they have a 72-day, your example was they have a 72-day license now, and upon the death of the 4% owner,
So
No.
say for instance, an owner has a 3-bedroom home and they live in the 1 bedroom and they rent out the other 2 that are taxed at 6%, maybe with a door in the hallway or something that separates that off, it's a private little ensuite. They can rent those 2 rooms for 365 days. As long as they're there, they're living there, they're in the house.
That's a better.
Yes, the owner does have, or the owner has the right to tell the guest, if you wanna come and use my kitchen, you can, or whatnot. But as far as renting the entire parcel, if they then go to rent the entire parcel, they can only do that 72 days or less. But the county is allowing those other 2 rooms to be rented for 65.
What we're saying is everybody who lives in a house that wants to rent that house, the entire structure, or any portion of that entire structure, can only do it for 72 days. Where everybody has the same.
I thought this was related to
No,
the-
no, it ain't
the
got
heirs.
nothing to do with
yeah,
that.
365 is a better breakfast.
I thought we had already decided that.
Can't have a bed and breakfast in
Right.
residential.
That's what I'm saying, that's like the legal bed and breakfast is what they're doing.
Right, so, this is ISTR for hardships. I've got further study needed, but part of that further study is hearing more from you guys, trying to define a situation where a current 4% owner who loses their 4% status, or not even loses their 4% status, due to some reason, needs to rent a house.
So let me go back,
Get an ISTR.
let me go back to the original concept for this. The original thought was, again, to answer residents' questions. If I need to go, if I need to go, I'm living by myself and I have a hardship where I have to go out of my home to live because I need care from somebody else, or I need somebody else to help me live. My initial thought was, if you needed to do that and you needed to rent your house to help pay for that care, you could get an ISTR. Now, if you get well and you come back home, you completely lose that ISTR. I don't need to know what your health problem is. All I need to know is you've had a certified letter from somebody saying he's living at Bishop Gaston or he's living at his son's house, and they certified that you're living there because you have to have help to live. Then other than that, I'm talking about help as that you can't function on your own. And other than that, I don't care. And if you get well and come back home, you lose your ISTR.
So would you think like a hardship ISTR to to where like every year you have to submit some sort of letter just to say that,
You have to continue, yeah.
yeah, and then and then when you stop getting that letter, that license just goes away.
Just dies.
You've gotta be able to discern what is a hardship though, because I mean, if I moved to the mountains and then, I mean, there's.
It's a medical put a medical
Yeah,
hardship.
yeah.
You don't wanna get into specifics.
For
though,
my
because-
asthma, I mean, I can now have an ISTO, I mean, I would think, we're gonna get back to the problem.
Assisted living was mine.
Okay,
Assisted
yeah.
living was my thing.
Yeah.
You had to go to something that was assisted living, not just,
Assisted living
not just,
hardship.
I'm moving to Arizona because my allergies are
Yeah,
bad.
yeah, but, yeah.
Move there.
I think there's a lot more that might qualify for hardships, and I'm all for allowing for compassionate exceptions if we can figure out a way to do it that Joe's comfortable with, that we're able to do. And I wouldn't want to put staff in the position of deciding yes or no. And perhaps one citizen suggested to me that we have like a compassionate review board, and that they could decide if it qualified as a hardship or not.
You know, you start to put people's business out there just too much, and at that time, if you're going through a hardship like that, that's the last thing you want to do, is talk about it with everybody that's none of their business.
Would you rather talk to a private group of a few citizens, or would you rather
I'd rather
approach
stay out of
council?
medical business
Would you-
and just have a medical,
I said that-
assisted living hardship in there, and that's the end of it. You
I'd
know?
like-
It's all in the details.
If you've gotta have some sort of note that says, yes, you qualify for this assisted living hardship, we don't need to know what the illness is, and it's your private business not to tell people.
Well, that's what I said last time, but,
Well,
I agree with Mr.
I mean,
Foley.
if it can be kept quiet, private, yes.
you still have to satisfy some sort of
I-
issue.
I-
I think Tim's letter was fine.
Yes, ma'am.
I think that we have no business knowing the details. I think it's a financial situation, in the sense of, I think there's a way to very fairly document that this is a financial hardship without knowing the details. Basically, I've done it myself in order to quantify that.
Don't say
And
financial
so-
hardship, because financial hardship opens you up to a whole lot of other
Okay,
things.
so I'm going to continue to define what I mean by financial hardship. If I do go into one of those circumstances, whether it be medical, whether it be a death, that incurs a certain, in my opinion, the language, lay language, that it's financial. That's your documentation. And there is a way of doing that with confidentiality, and if there needs to be a board to look at it,
There don't need to be I don't think it needs to be a board just because it's people's private business, and I've never had a board in Folly Beach. It keeps a
Who
secret.
would you have accept,
Who would I have accepted? I either administrator or, the administrator.
But if you had a certificate of occupancy or residency at a assisted living thing, that would suffice.
You just turn it into the
You just have some
administrator.
sort of doctor's letter that says you need this and that, you know.
Then
unless
he
you
can
got
call,
on your
then he
doctor.
can call the license holder, he can call,
Frankly.
Right, letters to city
I mean, they
school.
write letters, exactly.
They say write out letter, probably a pre-form.
yeah, so once he has that letter in hand, he can contact the, licensing bureau and say, 312 West Cooper can get a license, we have the documentation for this year, so they can get an ISTR license. If you wanna make it an annual requirement to have that, then that's
I
what
think when you turn in your, I mean, just like a license renewal, you have to have that just
Yeah.
to prove this a continuing thing.
That's
so
fine.
as the administrator, do you need any more definition of hardship, or you feel comfortable
Well,
with?
right now, what I'm hearing is the only thing that counts is moving to an assisted living facility.
But it wasn't necessarily a facility if you're living with your son, if you just need if you need assistance living. Not necessarily assisted living facility, but, you know, if you have to move for assisted living.
And just because, I just want, are we gonna say 3 out of 5, that, you know, you need assistance for 3 out of 5 daily living activities? I mean, because that's what you have to do to say claim disability from the government or veterans benefits. You say, I cannot feed myself, dress myself, bathe myself, transport myself. And if you can't do those things, the doctor says you can't, you get it. Especially if I'm gonna be in charge of it, I want crystal clear things, because what I don't wanna put the city in the position of, is Dr. Houghton got it because the secret board or the administrator felt bad that she lived with her mom, And he didn't, because he moved in with his cousin.
So
He's some
Doctors
standard.
do.
whatever that what is the standard you said the government goes by?
Activities of daily living, you whether or not you can or can't do them, and so something like that could work.
Well, pull that up for us. But here's the thing, even if you go to a family member, you'd have to have, I would say, you'd have to have a notary stamp your letter saying, I know this is true, when you turn it in.
Well, he said, doctors are a guy.
Doctors-
Or doctors, if the doctor will do it.
All you need, I think this is getting more complicated. You need a letter from a medical provider that says you need to have, you need to live in assisted living.
Yeah, you need assistance.
I mean, doctors-
Day to day.
Excuse me, Joe, you just said need to live in assisted living. These guys are talking about situations that are not you need to live in assisted living.
Well, I mean,
We're talking
assisted living,
facilities.
yeah,
Correct.
but
You need
assisted
assistance.
living is,
I just want to be clear. We're talking about need assistance, not need assisted living facility.
So if I was in a
You
Right,
get
take
catastrophic,
assistance
facilities
from-
out.
So if I was-
assisted living is.
Wait a minute.
Private or public or, right?
Well, yeah, but we got the word facilities to the end, and it makes it sound like
Right.
it's more private,
Yeah.
but that's, just leave the word facilities off of it, and y'all are on the same page.
All right, wait a minute. Sue, what's your question?
so if I had a catastrophic accident, does that include it if there's medical documentation? I want to get away, I guess, from assisted
If it's a
living.
medical documentation, you gotta go to assisted living because of your accident, yeah.
Move out of the house.
Or
If your
go home.
parachute didn't open, you can rent your house out.
I guess I want to get away from assisted living, in my
There's
opinion.
assistance with living activities versus assisted living.
It sounds like Joe's comfortable with that wording, and
Assistant.
But I do want to defer, I mean, Aaron, but I just, when I say assisted living, I mean,
You mean assistance?
with another family member
Okay.
or.
Your doctor's saying you have to have assistance with living.
Yeah.
You can't live by yourself.
You
I
can't
agree.
live by yourself,
I-
and that's it.
I agree
I
with
mean, I
that,
suspect they do that for other,
They
like you
do.
said.
Yeah.
They do.
and then
They were trying to tell me agree with that for years.
will we model it off of what you just said, the requirements?
I'll
No,
see
we
if
modeled it
there's-
off of the doctor saying you have to have
Yeah.
assistance to live. From a
We'll get
doctor's.
you guys
note.
some models.
Okay.
Okay,
So an ISTR for a doctor-supported documentation of need in some form, good for 1 year, recertification annually.
Yeah.
Man, we're getting right there.
And now to our favorite subject.
And as a interesting side note, if you move to an assisted living facility, you never lose your 4% tax rate.
Yeah, because you have to have a place to come home to by the state law.
So those are the amendments. The ones that we have some actual language for, we'll get to in a minute, and the ones we just talked about. So these are the only remaining open items, so I'm kind of heartened by that we're close. So I do think we're gonna need another meeting before February 13th, if we're gonna have first reading. I'm out of town from the 3rd to the 12th. So think about that and let's get a date and a time.
Next Tuesday.
Yeah, so not at this moment, but just let that simmer in your subconscious for a little bit. So now we have the wait list. So tell me if I summarize this incorrectly, just as kind of the basis for what the wait list turns out to be, some consensus from the last meeting. We have a two-phase.
Wait a minute, before we go any further with the wait list, let's all understand, the wait list is a moot point. It's trying to get it done before business license season. If we don't get it done till July, it doesn't matter because you still got more than 800 people on the list this year. So you don't have to rush through getting a wait list as bad as we needed to get the ordinance written. And in the ordinance, we can just say per the wait list and the wait list to be determined. Thank you.
Yeah, thank you. So two-phase wait list. The first phase would be awarded by lottery. We'll open applications at a certain date, keep the applications open for 30 days, close those applications, and then we give away licenses by lottery until everyone on phase 1 has a license. After that, we move to phase 2. Those are awarded from first come, first serve. We can open phase 2 the same day we open phase 1, a month after phase 1, whenever we open it, but no one on phase 2 gets a license before everyone in phase 1 gets theirs. So 2 phases. Phase 1, people apply, people get on the list. When they've all gotten their licenses, we move to phase two. Phase two is first come, first served from now until none of us are here anymore. So, and then just as a very basic set of criteria to apply, you have to be the property owner. You can only have one entry per owner. We'll get into that with a weighted list. Only one entry per dwelling unit. If you are selected, you have 30 days to apply. After we notice, you get notice of your selection. It's no fee. If we can, I've got renting without a license here as the thing that bumps you off the wait list. The wait list will be publicly accessible. So those are just the basic standards. Does anybody have any feedback on those basic standards?
I've always thought we should have a fee for it. Just a basic fee.
When we get into this next page and talk about wait list, which I'm in favor of, I think at that point, we need to have a fee associated, because it is, especially as we went through that last time, it was brought up, it's gonna be more for staff to deal with. So we need something to at least alleviate some of that financial investment.
Any other?
One thing I'm thinking of, the lost waitlist placement if convicted of renting without a license may re-enter after 1 year. If they're rent without a license, wouldn't you, something a little more harsh than that? I mean, that's,
Get banned and
I
permanent.
mean, if they did it 1 year loss, I mean, it sounds like that's a pretty good gamble.
Right.
You know?
Yeah,
I mean,
not
you
with
know,
it.
Not
I
when
take
you go
that
back to
chance.
the back of the list.
Yeah.
So you lose your license and then you,
Well, but again, if we lose 200 and, yeah, then, yeah, I got you on that.
Yeah, it does put you back at the bottom of the list, but if the bottom of the list is only 3 people away in a dream world.
Yeah, it doesn't, like I say, that, at that point, then it would be an incentive to rent without a license, because you can make more money in a 79-day period.
Right. All right,
I don't think
Because
it's
it would
bad to
take you a
have,
while to get caught. I mean, I would think.
I don't think it's bad to have some skin in the game with the fee, but I worry about, do we have to put that into an escrow account then and manage it or sit there? And then if you don't apply the next year, is it non-refundable or do you get it back?
Well, I don't,
A lot of questions.
I don't imagine a yearly application. Once you're on the list, you're on the list.
So it's a one-time fee is what I was thinking.
If you withdraw,
You're done. You don't get
it's
your money back.
a non-refundable.
Non-refundable.
So what would the reason for a fee be?
Well, we cover administrative costs. We could use it to do some other things with the STR enforcement, noise monitors, that type of thing. I mean, you got 500 people paying $100, we could buy noise monitors for the entire island. I mean, there's ways we could use that money to enforce and I think make everything better with the STR environment.
I think I'd have to just see the need for it and the amount.
I'm not talking more than $100.
All right, we'll look back at the penalty, in terms of the wait list. And we can brainstorm some stuff about fees also. So that's kind of the basic structure of the wait list. And then on the next slide are some options, for how that basic structure could be applied to different situations. So, option number 1, I'll admit that I'm biased towards this one because I feel like it's the easiest,
Me too.
and the fairest. It's just my personal opinion. 1 entry per owner, phase 1, anybody who owns property, anybody who owned property on February 7th and still owns it today, or on the day the wait list opens, becomes part of phase 1. So many people who owned property on February 7th who want to be on phase 1 join it. We give all of them licenses by lottery, and then we move to phase 2. Simple, straightforward. Second option would be a non-weighted but restricted entry for phase 1. So we don't necessarily give weight to individual entries, but we just narrow who can be in phase 1. I think at the last meeting, the only real qualifications I heard that folks thought about giving preference to were current property owners and multifamily or commercial buildings. So this would say If you live in a multifamily unit building, or you are in the downtown commercial or island commercial districts and you own that property on February 7th, you go into phase 1. And once all of those are gone, we start with everyone else in phase 2. The third one is just an example of a weighted list for phase 1. This keeps those entry criteria, well, that's every owner, but also owners of downtown commercial, island commercial, or multi-unit buildings get extra entries. You guys can debate the number of extra entries, and also the length of your ownership gets you extra entries. So the person who would have the most entries is the commercial multi-unit building that owned it the longest.
It's the investor who has the most units. We get the most entries.
Well, the basic rule says still only one per owner, so that owner would have to choose his unit. But a multi-unit commercial building owned for 10 years would rank higher than a single-unit commercial building owned for 10 years would rank higher than a multi-unit non-commercial building owned for 5 years, et cetera. So there's.
I know there's council folks who won't wait a list, but I think the easiest way and most fair way to everybody across the island from end to end is the first one you said. Here's, if you owned your property before February the 7th, you want to put in a fee or non-fee, you want to put in an application to be in the lottery, you put in your application to be in the lottery. Anybody who bought property after February the 7th that wants to pay the fee or non-fee gets to go to phase 2. I don't think just because you live in the commercial district or you own 3 condos or whatever that is, I don't think you should get any more rights than the guy or lady or family who lives on 1669 East Ashley Avenue, who's not in the commercial district, but has been there since, 1980, I don't think you should have more preference or more weight than that person would, personally.
I
They would
agree
get
with most of that, but I don't think somebody who bought February 1st of 2023 should have the same chance as somebody who's lived here for 20 years who's decided they want to go ahead and apply for an ISTR.
Well, if they lived here for 20 years, they would have had a place before February, right?
Yes.
Yeah, they'd have
but
the
I
same
think-
shot.
I think the determinant in the order would be the date of ownership. And if you've owned it 50 years and nobody else has owned it more than 50 years, then you become first. And if you've owned it 49 years and nobody else has owned it 49 plus anything, you're number 2. And if you bought it on February 2nd of 2023, you'll be the very last, assuming there was none before that, you'd be the very last on the phase 1.
That's gonna be tough for the administration to.
That,
You look at the deed number, I mean,
that's why the weighted balls in the lottery give them a better chance, but doesn't guarantee that they're number 1, but they have a better chance. So it's still fair to everybody on that list. They just don't have as much percent to get that number 1 selection.
I think seniority's fair. I don't think I have to give a chance or a ball in the basket for somebody who owned here one day before that deadline. I think we owe it to people that have lived here longer, and you just look at the deed number, and whoever has the lowest deed number is first on the list. Because then when it's time, and we get below 800, it's 799, and we award one, it's them, and they've got 30 days to apply, or it goes to whoever's here 49 years.
Yeah, so you're actually saying not a lottery as such, it's just
Seniority.
whoever has the most, whoever's lived here the longest, that owned the property longer would, so Miss Rhodes would be number 1 on the list. She's 99 years old, she's lived here forever, raised all her kids. So if she wanted to get a ISTR license or get on the list, she would be number 1.
I think she's earned it.
Well, I agree, she's earned it, she's well earned it over 50-some years of living here.
What if she doesn't want it year 1 though, and she's expired, she's off the list because she turned it down? But then year 2, she needs it.
Then she applies for a hardship if she needs it, but no, you have, now's the time to apply when you're serious
So then
about
what you're saying, essentially what you're saying is like, oh, since she got an ISTR through the lottery, she has a decision to make. She can move off the island she's lived on forever and rent her house out, or give up her chance at an ISTR. That's what decision would come down to.
Are you gonna allow 4% owners that stay 4% owners and they get on the wait list and say they're allotted a ISTR license, they get to keep their 4% status.
Well, it goes
Have a
back to the days
ISTR
rented
license,
too.
like-
You're gonna lose it. Most of these
The
people are
first
never gonna
ones to
use
apply
that.
for the ISTR.
They wouldn't qualify for an ISTR as a 4% owner.
No, they'd have to give up their 4%
But-
residence to qualify as
Correct.
an ISTR.
Could end up driving people off the island by doing that. And that's the exact opposite of what this entire thing was written to do.
You are kind of incentivizing people to move. If they get a license.
You're incentivizing our long-term
But
residents
wait a
to
minute.
move.
Well,
I mean,
if you-
honestly, that's
Okay,
what's happening.
so if you don't incentivize anybody, you just say if you wanna get on the list, you get on the list and you take your chances, you still,
Yeah.
if I get on the list and I get a number and then my number comes up, I still gotta say, yes, I want the license, or no, I don't want it.
Well, that's your prerogative, yeah. But
So it's the same thing.
It's
And
your
I think,
prerogative.
and I think that's a really thing I wanna make sure that everyone, how I intend, when I wrote all of these, is the wait list is for people who want a license when it comes up, not for people to get the option to wait for future years when they may need a license. You don't get on the wait list until you are ready to accept a license, because when your turn comes up, you get it or you don't.
You either take it or you leave
The
it.
wait list is not intended to camp on the wait list in the hope that one day in 10 years you can swoop in and say, I'm at the top of the wait list, I've been here 10 years.
So when we take additional things for phase one, all right, say Ms. Rose, just 'cause we were talking about her, say she doesn't get on this wait list, year one when we started. So then she needs to get on in year three. Does she still get into phase one?
No.
And what if,
No.
well, see, that's what I'm saying. So then she's not guaranteed a license even by these other ones.
How would she do it if you did the lottery like you're talking about, and she would have 30 balls in?
At least she's got more balls than anybody else.
But,
But the purpose of.
She has a better
Yes.
chance of getting that license than anybody
but
else.
the
Right,
thing
At the
is,
time when she's ready.
all right, but the thing is, you're right back to your first argument. She gets the license, now she's gotta make a decision. You're gonna take the license, move off
Well,
the thing and rent, or you're gonna give up the license?
The whole reason she waited till year three was because she didn't want a license, and now she did.
Well, we ain't gonna have a lottery every year. She's either gonna be on the weighted thing and get in, or she's gonna,
I mean, I was
not.
thinking about weighted lottery
Well, I
every
know
year.
what you're saying. But yeah, that's not.
That's the way to get around that. You do a weighted lottery every year, so then people aren't ready now. They don't
Oh,
have to miss
man,
the
that's-
boat just because they're not ready in
you're talking
2025.
about an
They get
administrative
screwed out in
nightmare.
2027.
No, you're
Plus,
talking about administrative
If you
nightmare
do a
there.
lottery
You're charging
every
for
year, then you really remove the ability for people to plan. Because you might be number 3 this year and you wonder, well, maybe I'll get it, maybe I won't, but at least I'll be number 3. I need to start getting my ducks in a row so that when I get the phone call that says you got it, you can do something. But if you do a weighted lottery every year, you might be 200
It
next
seems-
year, and
It
then
seems
you
like
can't-
every option we have in front of us, there's gonna be some winners and some losers.
Oh, yeah,
So
yeah.
we should just pick the one with the minimal amount of losers.
That's number one. Everybody gets on the, put your name in if you want it, and you
Or
take your chance.
Yeah, but you
Recognize-
continue the spread of rentals everywhere instead of trying to just move them in, but that's.
You
that's
don't,
what losers-
you can't, if you're smart, you can't say, I want all of my rentals in the commercial district, because you don't have enough room in the commercial district.
Of course not.
To
Nobody's
pay
saying
your,
that.
hang on a second, to pay your rate taxes, so it's gotta be spread
Ain't
everywhere.
nobody saying that.
Yeah, you are.
No,
When you're
I'm not.
saying you want all your things in the commercial
I
district,
didn't say all of them. I didn't say all of them.
so you still gotta spread. If it's down all in the commercial district, we still gotta spread.
I hear you.
If you wanna make a district, now, if you wanna make a district, that this is only rentals, you take everything on Front Beach and the first row behind Front Beach.
We looked into
that's
that
the-
before.
That's the district, that's 800 plus
We
houses.
looked into that before, and that didn't have any legs whatsoever, so
Well, you
let's
can
not
do
go
it-
backwards.
Well, you can do it the same way you're doing this.
We looked at it then, because we wanted to look into it, but we
I don't
didn't.
think that would fly.
It doesn't.
Oh, you can make it a special tax district.
Oh,
It's
yeah,
a-
I'm
it's a
fly.
different
You
process.
can do it, yeah.
It doesn't fly.
No one wants it.
Yes, ma'am.
Doesn't fly.
I agree with Mr. Folly. I believe that there is a way to look at seniority and quote weight it, whatever way we decide. So I would like to look at that.
When you say seniority, do you mean ownership tenure, or
Correct.
do you mean length of time on the list?
Nope, ownership.
All right.
So we're right,
So-
so you're right back to Mr. Well, hang on a second, you're right back to Mr. Rich's first argument, is if you do it by seniority, then Mr. Rogers gets, he has the land, the most thing, first one that comes up, you go to him and say, do you wanna move off the island and rent your house, or do you wanna give up your slot on the list?
I think people.
I think we can, like I said, we don't have to solve this tonight. And we kind of see the direction that we're heading, I think, to where Aaron may pull some more information, and we're gonna keep working on this for a while.
The
it
wait
seems
list
like.
is not, doesn't have to be tonight, it's the other stuff that has to be.
Right, that's what I'm
tonight.
saying, so we got, this, we've got us ball in a certain direction now, let's see what the rules say as we
And
move
I
forward.
think the foundational principle you guys need to decide on is whether you allow people to camp on the wait list, or if the wait list is only for people who are ready and willing to accept the license.
You can,
Part of, because if you allow people to refuse a license or basically camp out till they need it, that
so,
changes.
so
the
here's,
culture.
here's the
That's why you
thought
have to every
process.
year.
If I get on the wait list, I sign up my house, get on the wait list. When you come to me and say, you're up, I say, I don't want it, I'm off the list, that's done. I have that option to say, yes, I want it, or no, I don't. And when I turn it down, I'm not gonna get to go back 2 years from now and say, I want it, you're off the list. Or next time you go to the bottom of the 1,000 people that's on the wait list, and you wait your turn to come back up again.
I think when people realize that, they will not sit there and get on the wait list.
I don't think they will
arbitrarily,
either.
yeah. No, but I think that's a good way.
Now
to
they're
make
gonna
it.
move off the island and rent their house.
You're not gonna pay $100 to get on a list that you have no intentions of
Exactly.
taking you back.
In addition, I believe people are planful, they're reasonable, and they would then know what their options were. And if they decide, like the mayor said, to opt out, then they opt out. But I do think it's fair to look at ownership, length of ownership, in my opinion.
I think we're all saying that in some way, shape, or form. We just don't wanna screw anybody over or force them to make a bad decision.
I think what you hit the nail on the head is, no matter how this wait list comes up, there ain't all winners. Everybody's gonna say, well, I won on that wait list, or I didn't win because I didn't like the way you did it. So it's not gonna be, everybody's not gonna be happy. Again, everybody's not gonna be happy.
And speaking of winners and losers, and how you know you're a winner or loser is know where you're on the list.
Right.
And just to drive this home, if people above you have the option to say, oh, not this year, you will never know where you're on the list, because you will never know, I'm number 77, I get the 77th license. I'm number 77, I may get the 153rd license, or the second license, depending on what the people above me do. So, yeah, we arrange them by tenure ownership, that's great. But however we arrange them on the list, just the core principle, when your name is up, you get a license or you get off the list.
Yeah.
No maintaining your place on the list. And if we need to do it annually, and everybody can reapply and get on the list again, because they're serious and they want a license, that's one way to do it too. But that just prolongs the process, because all the people who aren't ready for a license keep getting on the wait list year after year after year, and turning down the first 10 licenses option. So the first 10 spots on the wait list basically permanently become the people who've lived here the longest, who never take the license, they just take the first 10 spots.
If you just throw this out there. If you look at it like this, especially if we're doing before the referendum date and after the referendum date. After the referendum date, everybody just goes on a list and just first come, first serve. You give everybody before the referendum date a chance to get a license, so you automatically rule out the 800, 900 that already have licenses, and then they can get into a lottery. And you figure with the minimum rental activity, the number's going to drop significantly. Where we'll have 100 or so to give away at first. That takes care of another chunk of people. Eventually, after 7 or 8, say 10 years, phase 1 will be over with, and then phase 2 would. Just thinking long-term future. After you get done with those, everybody who had a chance, then phase 2 is just first come, first served name on a list. We'll get to that point eventually. And with the minimums and all these other things, I think it won't take as long as we're thinking. I mean, I know 10 years is a long time, but it's really not.
But the key is to what Mr. Pope was just alluding to. When your name comes up, it's either you use it or you lose it.
Oh, exactly.
And
You
you're out of here.
lose it and you're off, and you go to the bottom of the other list, and that one is a statutory, just this is what it is. The first one, you can involve, because don't get on there until you're ready for it. Or we're down to the end of it, it's either you get in this year or you go to the bottom of this list. That's what it is.
Mr. Pope, though, I'm confident, as with anything that the staff does, there'll be communication, people will understand, they'll be notified of any process that we decide.
Is there any other, for lack of a better word, preference criteria than ownership tenure? that you guys wanna see move forward.
Just to, I'm okay with the weighted lottery. So just throwing that in there.
But no criteria other than ownership tenure. Is that good? All right.
Well, I just moved up the wait list a long way.
All right, now, just to go, since we are getting close to an actual ordinance, which will be up for a vote, I'm going to kind of work through some proposed ordinance language for some of the things that have more or less been settled.
Let's take it's a good time to take a 10-minute break. Stretch your legs and get your attention.